form will come to order as previously ordered. The presiding member is authorized to declare recess at any time. This is a continuation of a hearing that we began last week for reasons that still confound me. Today's witness was not here last week. I think it would have been more convenient for you, and I know it would have been more convenient for the members, but I don't run the department. So for whatever reason, you weren't here last week, you're here this week. With that, I'm going to have to administer an oath because that is what we do for all witnesses. So if you would please stand and raise your right hand. You solemnly swear the testimony you're about to give should be the truth, whole truth, nothing but the truth, so help you God. May the record reflect the witness is answered in the affirmative. With that, we are pleased to introduce today's witness, Mr. John Gore, who's the Acting Assistant Attorney General for the Civil Rights Division of the United States Department of Justice. You are recognized for your 5-minute opening statement.
Good morning, Chairman Gowdy, Ranking Member Cummings, and other distinguished members of the committee. The Department of Justice recognizes this committee's important oversight role, and on behalf of the department, I thank you for allowing me to appear today. The committee originally invited me to appear last week on May 8th as part of a panel with 4 other government witnesses from the Department of Commerce and the Census Bureau. I accepted that invitation, but in the days leading up to last week's hearing, the committee informed the department that the committee had added a non-government witness to the panel. It is long-standing Department of Justice policy and practice to decline participation in committee hearing panels that include a non-government witness, particularly when the department is involved in litigation regarding the subject matter of the hearing. Accordingly, before last week's hearing, the department reached out to the committee and offered several accommodations that would have allowed me to provide testimony last week. Those accommodations included moving the non-government witness to a separate panel, allowing me to submit written testimony and written responses to questions for the record, or postponing the hearing. The committee denied those accommodations. The Assistant Attorney General for Legislative Affairs, in consultation with department leadership, then made the decision on behalf of the department that I would not appear at last week's hearing. After further consultation with the committee this week, the department has decided that I would appear voluntarily today without any non-government witnesses and without the committee issuing a subpoena. The Department of Justice is resolutely committed to the full, robust, and even-handed enforcement of the nation's civil rights laws and to free and fair elections on behalf of all Americans. The department's mission is to ensure that all Americans have a full and equal right to vote, regardless of race, color, language, or military service. And we are fulfilling that mission all across the country. Since January of 2017, the Department of Justice has participated as a party in 3 cases under Section 2 of the Voting Rights Act, and we have resolved 3 other cases under the National Voter Registration Act. Those 3 resolutions ensure that eligible people will be able to register to vote and remain registered. The department has participated as an amicus in 3 voting rights cases, including another Section 2 case and a case seeking to protect the voting rights of members of a language minority group in one of America's largest cities. The department has continued our election monitoring program and our outreach and enforcement efforts under Section 203 of the Voting Rights Act, which protects the rights of language minorities. The department is also zealously protecting the voting rights of our brave men and women in uniform and other overseas citizens through the Uniformed and Overseas Citizen Absentee Voting Act. In 2017 and 2018, the department assisted several states in achieving compliance with UOCAVA for their special elections. And in February of this year, the department filed and resolved a voting rights case under UOCAVA involving the state of Arizona. The department is gearing up for the 2018 elections as well. We are working day in and day out to ensure that those elections are conducted in accordance with federal law requirements. In furtherance of the department's ongoing commitment to the fair and full and even-handed enforcement of the nation's voting rights laws, on December 12, 2017, the department sent a letter formally requesting that the Census Bureau reinstate onto the 2020 Census Questionnaire a question regarding citizenship. That question previously appeared on the short form of the census and the long form of the census, and it currently appears on the Census Bureau's American Community Survey. The department's letter explained that accurate citizenship data is crucial to the department's enforcement of Section 2 of the Voting Rights Act and its important protections against racial discrimination in voting. To fully enforce those requirements, The Department needs reliable citizen voting age population data in localities and census blocks where voting rights violations are alleged or suspected. Since the Department submitted its letter, 4 lawsuits have been filed challenging the Department of Commerce's decision to reinstate the citizenship question onto the census questionnaire. The Justice Department is defending those lawsuits. In deference to the courts charged with adjudicating litigation involving the United States, the Department's longstanding policy and practice is to decline to make statements regarding that litigation outside of court. The Department accordingly is constrained in its testimony today. As I said at the outset, the Department takes this committee's oversight role very seriously, and our goal is to be as responsive to the committee as possible. But in light of the pending litigation, the potential effect any public statements might have on ongoing court cases, and the Department's litigation constraints, I am unable to make any statements today beyond those in the Department's letter and other publicly available information. The Department thanks the committee for its understanding of these constraints. Thank you.
The gentleman from Wisconsin is recognized.
We'll give you a few questions here. What data does the Civil Rights Division receive from the Census Bureau?
The data we receive from the Census Bureau, Congressman, there are 2 different forms of data we receive from the Census Bureau. We don't receive any individual responses to census questionnaires, whether that's the decennial census questionnaire or the ACS questionnaire. What we receive is aggregations of statistical data that compile the individual answers into statistics for geographic areas.
Give me an example of how you use that data.
Sure. So, for example, in our Section 2 enforcement work, we need information at the census block level. The census block is the smallest unit of geography that the census collects data on. For example, the Census Bureau's information says how many people live in the census block and what their race is, which is important for Section 2 of the Voting Rights Act. And then the ACS data provides estimates of citizenship rates, but not at the census block level, at either the block group or tract level.
So you really have to know if anything was going on, the amount of people there who are legal and illegal, correct?
For our purposes, in the Civil Rights Division, what's important to know is racial data and citizenship data at the census block level. And currently, we don't receive census citizenship data at the census block level. That has to be extrapolated from ACS estimates, which are only available for larger geographic units.
And give me a hypothetical why that matters. Give me
Sure.
an example of a situation.
Sure. So the easiest way to think about it, Congressman, is that a census block is the fundamental unit of a district.
And so we know just how big is the census block? Maybe, I'm sure it varies greatly, but
It does vary greatly. Think about it as maybe a city block or a suburban block, and the population of census blocks can vary all across.
10 houses maybe.
Could be.
Yep.
Could be a single apartment building.
Yep.
And what a redistrictor has to do is collect a number of census blocks to form a district. And so the census block information gets aggregated up to the district level, and that's how you know how many people are in the district for one person, one vote reasons. It's how you know the racial composition of the district for voting rights reasons as well. And so the citizenship data is crucial because in many Voting Rights Act cases, you need to know citizenship rates to understand whether the district is performing for a particular minority group.
I'm trying to think how it would even come into play. Let's pretend we got a block of 10 houses, and in those 10 houses there are 23 adults, and 5 of them are illegal, and I really don't like, I hate the idea of labeling people by race, because I think there are other ways to label people, but I guess that's what we're obsessed with here. And let's say of those 23 people, 6 people are a minority, of which 2 are the illegals and 4 are citizens. What do I do with those data? How would that possibly come into play? What are you going to do with that data?
Sure. Thank you, Congressman. Thank you for your question. What we would do with that data is we would analyze the district to determine whether it complies with Section 2 of the Voting Rights Act or suggests a Section 2 violation in that geographic area.
How would it comply or not comply?
Section 2 requires, it prohibits what's called vote dilution. And so in certain circumstances, Section 2 requires redistrictors to draw districts that have a majority of a minority group within the district that can elect its candidate of choice. That's a fundamental protection of Section 2 of the Voting Rights Act. So once you've put together the census blocks and aggregated the census block information on the district level, you know whether you have a Section 2 district or a Section 2 problem, because it may be that a map drawer has split the minority group into 2 different districts or has otherwise manipulated district lines to violate Section 2.
Just a second, and I know you're not the one who drafted the law. Isn't there an assumption there, a little bit of an assumption, that people, when they go to the polls, rather than being, I would argue, intelligent people and voting on people's candidates' opinions on transportation or education or taxation or whatever, that people are expected to vote for people by race?
I don't believe that's an assumption. One of the fundamental requirements in a vote dilution case is to show that there's racially polarized voting, and that doesn't exist everywhere in the country, but where it does exist, Section 2 can be triggered in a vote dilution case. And racially polarized voting refers to members of a racial group tending to vote together for the same candidate.
Okay. I think that's a very inappropriate assumption, and maybe we should look at the law sometime, because I would hope there are a lot of Americans who just go to the polls and vote for someone of their same racial background. But thank you for...
Gentleman yields back.